Ready? Exercise number 14, legal matter, which contains 1000 word and very important matter. Start. We have heard Sri K.R. Sirohi, learned senior advocate assisted by Sri Amit Malik for the petitioner. Sri A.K. Misra, learned counsel appearing for the respondent number 3, and Sri Maya Shankar Srivastava, learned counsel appearing for the respondent number 2, as well as learned standing counsel. Pleadings of the parties having been completed with the consent of learned counsel for the parties, this writ petition is finally decided. Brief facts of the case as emerged from pleadings of the parties are as follows. The Government of United Provinces, under the provisions of the Land Acquisition Act 1894, acquired 277.42 acres of land for sewage farm for the drainage of Allahabad municipality. The notification under Section 6 of the Land Acquisition Act was published in the United Provinces Gazette dated September 11, 1915. 277.42 acres consisted land of two villages of Paragna Arail, that is village Jahangirabad 204.07 acres and village Maheva 73.75 acres. The acquired land was transferred and vested in the Municipal Board Allahabad in 1915 itself. A part of the land which was acquired for sewage farm was given on short-term allotment to various persons, including the father of the petitioners. Plot number 62/3, area 4 Biswas. Plot number 61/3, area 4 Biswas. Plot number 44/2, area 15 Biswas. 48/1, area 12 Biswas. 83/2, area 2 Biswas. 84/3, area 4 Biswas. Total 2 bighas and 1 biswa land was given on short allotment to the petitioner's father. A case under Section 175 of UP Tenancy Act, being case number 65 of 1958, was filed by the Municipal Board against the father of the petitioners, in which a compromise was entered on 31/10/1958. That father of the petitioner shall not claim any occupancy right, and after settlement up to 31/1/1971 he will vacate the land, failing which decree of eviction shall be treated to have been passed against him. Notice was given on 18/6/1964 to the father of the petitioners for vacating the plots on 12/10/1965. The Municipal Board decided to give short-term settlement for 5 years more to the occupants on the rates of Lagan as fixed in the decision. After expiry of the 5 years, no further settlement was made in favor of the occupants, including father of the petitioners. A suit under Section 175 of UP Tenancy Act was filed by the Nagar Nigam against the occupants who were earlier given short-term settlement for their eviction. One of the case was also filed against the father of the petitioners. In all 64 cases were consolidated, and trial court framed a preliminary issue as to whether UP Tenancy Act 1939 was applicable or not. The preliminary issue was decided by the trial court on 31/7/1978, holding that UP Tenancy Act has been repealed by the UP Urban Area Jamindari Abolition Land Reforms Act 1956 with effect from 1/7/1963. Hence, the UP Tenancy Act 1939 is no more applicable. The suit under Section 175 of UP Tenancy Act was held to be not maintainable, with the observation that cases for eviction be filed under UP Public Premises under bracket eviction of unauthorized occupants bracket out Act 1972. First appeal was filed before the Commissioner, which was dismissed on 28/10/1978. Second appeal was filed in the Board of Revenue, which too was dismissed on 17/2/1992. Board of Revenue took the view that the issue as to whether suit could have been proceeded under UP Tenancy Act ought to have been raised before the district judge, who was authority competent to hear the appeal. After dismissal of the second appeal, proceedings were initiated against the father of the petitioner by Nagar Nigam Allahabad before the prescribed authority / subdivisional officer for eviction under 1972 Act. Father of the petitioners died on 16/3/1995. Thereafter, the proceedings under UP Public Premises (eviction of unauthorized occupants (out) Act is not said to be proceeded with. A decision was taken by Nagar Nigam Allahabad on 24/2/2005 to transfer 45 hectares of land of Naini Suele's farm in favor of the Allahabad Development Authority. At the rate of rupees 10 per acre, the respondents have alleged that possession was transferred to Allahabad Development Authority on 25/2/2005. After the claim of the respondents, the possession of 45 acres of land situated in village Jahangirabad, Uparhar, having been taken on 25/2/2005, several writ petitions were filed in this court praying for a writ of mandamus directing the respondents not to dispossess the petitioners from the property in dispute. The writ petitions were filed by several occupants who were claiming to be in possession of plots on which possession was sought to be given to the Allahabad Development Authority on 25/2/2005. The writ petition number 76191 of 2005, 30679 of 2005, 72134 of 2005 and 72135 of 2005 were filed by occupants. The writ petition number 76191 of 2005, Muhammad Mustafa and others versus State of UP and others, and all above other writ petitions were dismissed by this court on 23/3/2006 by following order. These writ petitions for a direction to the respondents not to dispossess the petitioners from the property in dispute. We have heard the learned counsel for the petitioners, the standing counsel Sri B.B. Paul, Sri G.N. Verma, Sri D.C. Tripathi, Sri A.K. Misra and Dr. Abda Sayyed for the respondents. The petitioners may, if so advised, file a suit for declaration and injunction. With these observations, the writ petition is dismissed. Against the order of this court dated 23/3/2006 dismissing the above writ petitions with the observations that the petitioner may, if so advised, file a suit for declaration and injunction, special leave to appeal number 7564 of 2006 was filed in the Apex Court, which was dismissed by the Apex Court on 8/5/2006. Subsequent to the dismissal of the special leave petition, the occupants filed civil suit in the Court of Civil Judge (Senior Division (out) Allahabad, being suit number 384 of 2006, Nizamuddin and others versus Nagar Nigam Allahabad, suit number 478 of 2006, Iqbal Ahmed and others versus Nagar Nigam Allahabad, and suit number 483 of 2006, Wasimullah and others versus Nagar Nigam Allahabad. In the said suits, relief of the perpetual injunction against the defendant respondents was prayed for. Full stop. Thank you very much. Guys, there is one humble request. Always try to repeat the matter, then only your accuracy and fluency will improve. And also there is one more request. If you found the matter is excellent for exam purpose, you can give your valuable comment on my YouTube channel. And also for next matter, please subscribe my channel. Thank you very much, guys.